Does a letter threatening possible legal action for libel constitute a retaliation under the executive law? To find out, you have to read Clifton Park Apartments versus New York State Division of Human Rights. But it's 9 pages. Don't have time for that? I've got you covered. This is TLDR, Too Long Didn't Read, where I cover New York Court of Appeals cases and I try to do it in 5 minutes or less. This is the episode on the case of Clifton Park Apartments versus the New York State Division of Human Rights. The citation for this case is 2024 New York Slip Opinion 00793, published by the New York Court of Appeals on February 15th of 2024. The issue in this case is whether the threat of litigation is an adverse action that can support and establish and substantiate sufficiently a retaliation claim under the executive law. To understand the background, this case a little better, to get the context, you should know that the human rights law, which is found in Executive Law Article 15, makes it unlawful. A couple things. It makes it unlawful to discriminate on the basis of protected statuses, gender, race, family status, several other areas with respect to housing. So housing discrimination is illegal, but also there's a part of human rights law that says it's unlawful to retaliate against a person for opposing discriminatory practices. So retaliation is unlawful if you retaliate for filing a complaint based upon discriminatory practices. The burden in a retaliation claim is on the plaintiff to establish a prima facie case, which is number one, it's got 4 elements. Number one, that the plaintiff engaged in protected activity. Number two, the defendant was aware that the plaintiff engaged in the protective activity. Number three, that the plaintiff suffered an adverse action based upon that activity. And number four, that there's a causal connection between the protected activity the plaintiff conducted and the adverse action the plaintiff suffered. So that's the background that's helpful to understand this case. The facts are that there's this City Vision is a Texas-based not-for-profit corporation. It's a testing corporation, and their function, their mission is they try to ferret out unlawful housing discrimination by landlords and property owners. And then if they find it, they file discrimination complaints. They do this by posing as the people that work for City Vision and other agencies like this pose as prospective tenants looking for housing. And then they raise issues that might flag discrimination. They say, "Oh, I have family," or "I have my cousin is from Cuba," or whatever it is they're trying to find discrimination in the form of. So in 2016, City Vision and City Vision agent placed a test call to the Clifton Park Apartments as an owner, which is the owner of Pine Ridge 2 apartment complex, which is a housing development in New York, purporting to seek an apartment to rent. In that call, the City Vision agent claims that the Pine Ridge facility steered them after the agent said, "I have a child." The Pine Ridge facility then steered them to another building, not the one they were looking to rent. And they claim that this was discrimination on the basis of family status. City Vision then filed a discrimination claim against Clifton Park and Pine Ridge with the Division of Human Rights, alleging discrimination based upon family status, a violation of Executive Law 295 5A1. DHR, the Division of Human Rights, investigated this complaint, which is what they're required to do, investigate it. And if there's probable cause, then they have a hearing. But here they found it lacked probable cause to support any finding of discrimination. So they dismissed the complaint. Never was a hearing. At that point, Pine Ridge goes on the offense. They were very upset by this, and they go on the offense, and they sent a lawyer letter to City Vision saying they consider the allegations made in the complaint to be libelous, and they were looking to City Vision and the agent of City Vision to personally come up with pay them back for the damages that they suffered in terms of reputational damage for the wrongful conduct. City Vision claims that they were shocked. They had to scurry to find a lawyer. And at that point, City Vision files a second complaint against Pine Ridge. Now, not for the original discrimination in the basis of housing. Now they file a retaliation claim against Pine Ridge, saying that they're retaliating against them for filing the original discrimination complaint. At this point, an administrative law judge conducts a hearing on the retaliation and does two things that are at issue in this case. First, puts the burden on Pine Ridge to show that the initial discrimination claim was made in bad faith. and says that they failed to do so. And the second thing is that as to the damages element, they find that the actual adverse, that the letter itself was threatening and constitutes an adverse action. That the letter itself, the lawyer letter saying, if you don't make this right, we're going to take appropriate action, that was a sufficient adverse action to justify a retaliation claim. And they assess damages against Pine Ridge. It gets appealed. Basically, they file an Article 298 proceeding to annul the Division of Human Rights finding, goes to the appellate division, and they dismiss the case, finding there was insufficient evidence of an adverse action. It goes to the Court of Appeals. At the Court of Appeals now, there's two issues that they're looking at. Was the sending of the lawyer letter a sufficient adverse action that it satisfies that element number 3 of the retaliation claim, prima facie case, those 4 elements I talked about? And they say they reject the per se notion that a letter is not sufficient. They say it's a fact-based analysis, and they give deference to the Division of Human Rights. And they say, well, the standard here is a reasonable person. Would a reasonable person have found that the challenged action materially adverse, in that it might have dissuaded that reasonable person from making or supporting a charge of discrimination? And they say the Division of Human Rights has expertise in this area. They say it's sufficient here. So we're going to, and it's based on substantial evidence in the record. So we're going to give deference to that finding. But as to the element number 1, they say that the ALJ, the administrative law judge, had the wrong burden of proof here. Instead of requiring the plaintiff, instead of requiring City Vision to establish that it was in good faith, the ALJ required Pine View to establish there was bad faith, and that was wrong. So they say DHR, the Division of Human Rights, should have required City Vision to demonstrate that they were engaged in a protected activity, not the other side to show that it was bad faith. The plaintiff here should have had to establish that the original complaint was a protected activity, including that it was a legitimate complaint. So they say that because the Division of Human Rights had the wrong burden of proof that they used to analyze it, they send it back down to them. They remit the case back down to them to make a factual finding on that issue, and the judgment is reversed, and they send it back down. That's the case of matter of Clifton Park versus New York State Division of Human Rights. Have a good day. If you like what you just saw and want to see more just like it, please hit like or subscribe to let me know.